Okay, so this class I am taking after a long time, right? And I've already told you, right, that in this class, I did not took it for around around one month or so, right? I think 1 month, yes, around 1 month I did not took the class, right? The reason was I was very busy with the other classes, right? Because of Corona, I started this class, right? So I was a little bit busy about that, okay? But I have completed almost paper one. Only I think 4 or 5 topic is left, right? Rest every topic I have already covered, right? So in that 1 month, hopefully you have covered all that topic, right? So today I will be starting with the rest topic, right? That is the international law, topic number 10 and topic number 11. Okay, so topic number 10 and topic number 11 I will be talking about today. Okay. Now, after topic number 10 and 11, there are 4 more topics, right? So in the next 2 weeks, right, international law will be over, right? So the constitutional law is already over, right? So international law will be also over, by in next 2 weeks, okay? So I will suggest you to study at least these 2 topics, right? Now I must tell I got a lot of email when I discontinued it, right? Somewhere telling me that, sir, you have left it in between, right? So see, that is not, I have already told you, right, when I started this, that in the time of Corona I am free, that is why I am doing it, right? But nowadays everything has happened in the home only, right? So de facto people have actually installed camera and everything, and I have started to take class, optional class in the home only, right? So that is why I discontinued this class, okay? But still, someone, if you have asked me, right? So I requested them that at least we should start it, right? At least we should start it, okay? So let us start with this, okay? Now, today 2 questions. Now those who are joining us for the first time, right, let me briefly explain them as well, right, that what we are trying to do here. That see what happens, that each week I will take 2-3 topics, right, and I will explain that what to study in that particular topic, right? It means what are the subtopic that need to be studied in that particular topic, right? So that will be the structure of the class, okay? I will take a topic, then I will disintegrate that topic into multiple parts, that what are the subtopic that has to be studied, and that will be based on the previous year paper, right? That will be based on the previous year paper, right? And also I will be discussing one paper, right? Previous year paper, some of the questions are there. I will discuss that also, that how you can actually approach them, okay? So that is what I am doing. Now one thing that I used to do, that I used to check also one copy, right? So again I will do the same thing, that is not an issue, okay? I will give you one question to write, okay? And you submit me, right? But again I will not take everyone's copyright. I will take any one of your copyright and I will evaluate it, okay, in front of you, so that you will be able to understand that how to write answers, okay? But do not expect each and everyone to get their copy checked. I will simply pick up one copy from all the copy received, okay? Because it will take otherwise a very huge time, right? It will take otherwise a very huge time, okay? Done. So that will be the whole structure, okay? So those who are joining me for the first time, right, so let me explain them. Those who are older students have already studied, they must be doing it, okay? Okay. Chaliye, so let us start with the 2 topic that we will be covering today, right? The first topic is the lawful recourse to force, aggression, self-defense and intervention, okay? That is the first topic. Second topic is fundamental principle of international humanitarian law, international conventions and contemporary developments, okay? So that is the 2 topic that I will be discussing it. Let us go one by one, right? First let us talk about lawful recourse to force, right? So first you have to talk about, you have to study that what is the meaning of lawful recourse to force, right? Now identifying a lawful recourse to force, or whether you are allowed to take a recourse to force, right, that is only allowed in the case of aggression, right? So this lawful recourse to force, right, that can only happen when some country attacked you, right? It means the first important thing will be the identification of who is the aggressor. That is why you must have seen, right, that sometime what happens, that if 2 country fights, right, the first statement a country gives, that I am not aggressor, you are aggressor. Why they are trying to say that other party is aggressor? Because once the international law recognizes that the other party is aggressor, it means you have a right to self-defense, okay? Then the next part comes, right? Then the right of self-defense arises only because someone have been identified as aggressor, right? So we have to study that what do you mean by aggressor? International law or case law related to the meaning of aggressor, right? How do you define aggression? Okay, so aggression either should be directly against the government, or aggression can be against the sub-government. right? Like suppose Pakistan is attacking, right? Now Pakistan is attacking, some part, cyber attack, suppose, right? Now Pakistan is attacking in some part of the country with respect to land forces, right? So which of the following will count as aggression? Right, so that is a very new development, that how do you count aggression. Recently also you must have seen that the Chinese government that issued their statement after they were ordered to shut down their embassy in US, that this is an aggressive act. Okay, it means I have a right to respond, right? I have a right to respond, right? So the first you have to understand the meaning of aggression. How do you identify aggression? Okay, and case laws, International Court of Justice case law, that how they have defined aggression. Okay, that you have to study. Then or how will you, what are the judicial principle on the basis of you will identify the aggression, aggressive party who have aggravated. Then you will come to the self-defense, right? Now once the aggression is established, then the right of self-defense starts, right? Now right of self-defense, I have given in notes also some of topic in the case of self-defense, right? See, right of self-defense is basically an inherent right that can be traced into, right? One is international treaty law, right, which have identified, right, and next is actually your customary law, right? So customary law also identifies right to self-defense. Why? Because for any object, right, of any subject of the international law, right, whether it be individual, whether it be a state, right, survival of them is the most important thing, right? Okay, so law protects it, right? So if the survival of a state of the state is at stake, then the right of self-defense starts. That is a very natural consequence, right? Understood, right? So you have to understand the meaning of self-defense, the cause of self-defense, why self-defense, why it have been said a part and parcel of international law, right? Then you will talk about, and there are two law, right, customary and international treaty. We will talk about that. There is a very famous case law, Catalina incident, right, happened in the US back in 1863-64 only. I will talk about it. Then you will talk about the third topic of it, that is your intervention, right? Intervention. Now see, intervention basically is of two types. One is called lawful intervention and other is called unlawful intervention, right? So we'll talk about the type of intervention, okay? Lawful and unlawful. Which intervention can be said to be lawful intervention, which intervention can be said to be unlawful intervention. Now the question is, what is the meaning of intervention? So intervention is a very simplistic definition. If you have identified a aggressor and you want to do self-defense, right, then you need to intervene in some other territory, okay, right? So intervention can be for the self-preservation of the state, or intervention can be just to protect the human right abuses, okay, just to protect the human right abuses, okay? So remember that intervention can take place in the pursuance of the protection of the state itself, right, existence of the state itself, okay? It means in the case of self-defense, right? And second, intervention can be done for the purpose of stopping the abuse of international law, especially international humanitarian or human rights law. Understood? Okay, now in the case of intervention, when you do in the case of self-defense, that is called preemptive self-defense. Like recently, when Pakistan was attacked by India, then what happened that in Balakot, I am discussing it, please don't message in between, let me first complete, then I will take the question also, okay? Please let me complete, because the chain of thought breaks, okay? So that is why. Now if you will look at the Balakot strike, right, so just right before Balakot strike, what India started to say, that there is a preemptive, there is an attack that is imminent on India, right? And then they justified their intervention. Okay, right? So intervention can be for the can be one of the recourse that can be taken in self-defense, and the second type of intervention that can be done is basically in the pursuance of your abuse of the international human rights and humanitarian law. Understood that particular? So that has to be studied in very great detail. Okay, then the second subtopic, right, that is your fundamental principle of international humanitarian law, right? Humanitarian law, remember. Now the one thing that always comes in exam, right, like the 2019 also this paper was there, or I think in 2017 also there, 16 also there. Each year, practically one question is there from this topic, and that is this itself. That is, what is the difference between human right law and international humanitarian law? Now some of the principle of both of them actually overlaps. Some of the principle of human right laws and some of the principle of humanitarian law overlaps, right? So you have to talk about that. What is that overlapping part? Understood? And then you have to come specific, right? Okay, this is the one of the principle that is only applicable to the humanitarian law, and this is the principle that is only applicable to the human rights law, right? Now, briefly speaking, what is the difference? You must be knowing, in the case of a humanitarian law, it is a law of war basically, right? It actually, gives you certain, duties, or the certain law that you will not violate in the event of war. Right? Now in the event of war, right, the things are very flexible, right? It means ki there are some exceptions that is attached to the international humanitarian law, but that is not the case of in the case of human right law. Human right have no exception, right? Second difference is basically humanitarian law is against a particular country, right, as a whole, right? So it is given in bulk, right? Against a community this particular right have been given, right? But in the case of human right law, it is given to individuals. Okay, right? So one is have a very microscopic applicability and the other is a very macroscopic applicability. Okay, so that is the two major difference between international IHL humanitarian law and international human rights law. Okay, so that is that is the one thing that you should keep in mind. Okay, then you talk about all the major conventions, right? We have Hague and Geneva conventions, right? So I will not ask you to read all the Geneva Convention in detail. That is very huge actually, right? In optional class also I do not dictate each and every Geneva Convention, right? But what you have to do that you have to pick and choose. See previous year paper and pick and choose because these are the conventions that are more important. Okay, just prioritize the conventions, right? Now when you prioritize the convention, you should actually understand those conventions with respect to principles that is there in the case of the international humanitarian law, right? Because each of that principles is ingrained in the conventions, right? So you identify that which principle is ingrained in which particular convention, and you have to pinpoint articles also, right? By Geneva Convention 1949, right? Article 48 or 43 talks about principle of necessity, right? For an example I am giving. Okay, so you have to identify the exact article, right? You have to identify the exact article which gives effect to multiple principles, right? Principles of proportionality, principle of necessity, right? That also I will discuss. I have given there as well. Okay, then the third aspect of international humanitarian law that they ask you is that sometimes international humanitarian law is related to particular subjects, right? Meaning with respect to cultural property, right? With respect to captured armed forces, right? Like in the case of captured armed forces, international humanitarian principle says that you will honor their rank. It means if you have captured a Jawan, if you have captured an officer, right? So even after capture you will honor their rank. I believe you will treat them differently. Okay, so that is something very interesting actually, right? So it means you don't have to study international humanitarian law only with respect to general principle, but also you have to go into detail with respect to individuals, right? With respect to armed forces, what is the international principle? With respect of this medical personnel, like in the case of medical personnel, one of the principle is that they cannot take side, but they cannot take side, but they will be considered to get the protection only when they do not take side. As soon as they take side, right, even indirectly their the exception is there. It means their privilege that they have under the international humanitarian law cease to exist. Okay, right? So that is why I told you in the case of IHL there is a lot of exception, but in the case of human rights law exception is there. Okay, so that is a primary difference sort of, right? That is a primary difference sort of, right? So that one thing is also you have to read, right? In the case of cultural property, right, Tora Bora mountain range, you must have seen in Afghanistan, Lord Buddha's huge figurines, right, of 3, 4, 5 century BC that was actually destroyed by the Taliban. Okay, so that is one of an international law crime, right, with regard to cultural property. Okay, understood, right? So this is the sort of 8 subtopic in these 2 topics that you have to study, right? That you have to study. Now, as in the previous notes, I have taken some of the topics and I will try to explain you that particular topic, right? Not in detail, but at least you should be able to understand by self-study. You can do it. Okay. See, the first is right to self-defense. Now, I have told you the right of self-defense in international law originates in 2 ways. First is one, Caroline incident. I have told you Catalina. I am very sorry. Caroline incident, right? That Caroline incident was a very interesting case. Actually, what happened? It happened between British and Americans, right? So there was a boat, which the Britishers, army personnel were there, arms and ammunitions were there, and that was destroyed by the US. Okay, why? Because they thought that this boat might be used for attacking us, right? And and that boat actually lied on the Caroline. That particular boat was lying between Canada, which was still under the capture of Britishers, right, and the US. Okay. Now the question arose that what is the justification that the US can give, for having that boat, submerging that boat, attacking on that boat, right? So there, for the first time, this concept of self-defense came, right? The customary understanding of self-defense is not only the exercise of a state right in response to a military attack, but also counter an imminent threat of armed attack, right? So the self-defense can be correlated with can be correlated with preemptive self-defense, meaning कि it should not be there that once you're attacked then only the self-defense will start. The self-defense might start before an attack if you know that the attack is imminent. Okay, so the customary law identifies self-defense after attack as well as before attack. And what is the rationale? The survival of the state, survival of any particular subject is the most important thing in their life, right? So obviously if we talk about a state, so survival of stake is the most important thing, right? Like for an example, right, in IPC also if you will read, right, so if you will do conspiracy to commit a crime against the overthrowing of the government of India, that is a crime, right? Generally the conspiracy by default generally is not a crime, right? But in some cases it have been specifically held as a crime. However, in 1913 obviously conspiracy was added as a separate crime, that I understand in our IPC, but normally speaking they are not considered as a whole crime, right? So preemptive self-defense was not considered as a norm, but after Caroline incident it have been considered a norm. It means it has now been a well established principle recognized by international law that preemptive self-defense is part and parcel of self-defense. Okay, so the India when attacked it, right, so obviously India was exercising preemptive self-defense. Okay, now when you talk about the treaty, right, so the one article that you will always cite in the case of self-defense is basically article number 51 of the UN Charter, right? Now if you read this particular UN Charter, article 51, it do not directly say that you have self-defense. It actually indirectly sort of smudge it up. Let us read it actually, very interesting. See, nothing in present charter shall impair the inherent right of individual or the collective self-defense if an armed attack occurs against the member of United Nations. Right? So it do not say that you have a right to self-defense. It say nothing in the charter will stop you in exercising the right of self-defense. Right? So this article is basically recognizing the existing customary right of self-defense under international law. Okay, so this article, I mean UN Charter is not giving you right to self-defense. It is simply recognizing what is already been in existence, right? What have already been in existence. Okay, until the Security Council had taken measure to maintain international peace and security. It means it is saying the limit of self-defense. That see, this right exists until the Security Council have taken measures. It means if the Security Council have taken measures, your right ends. Okay, your right ends. Let's stop. Measures taken by the member of exercise of this right by self-defense shall be immediately reported to the Security Council. Now that is a procedural limitation on the right of self-defense, that once you exercise a right of self-defense, then you have to inform about that to the Security Council, that yes, under this charter I have exercised this particular right, right? So the information has to be there, right? Then and shall not in any way affect the authority and the responsibility of Security Council under the present charter to take any time such action as is deemed necessary in order to maintain or restore international peace and security. Now it is saying that see, even if you exercise the right of self-defense, you inform us, everything is proper, but still then also Security Council reserves the right to take any action. It means it is saying that see, your right to self-defense will subsist, right? But the authority of Security Council cannot be overtaken by this customary right of self-defense. It means that both will persist parallelly. Right? Both will persist parallelly. So, you understood? So that is a very, very important article, right? In fact, it whenever there is a question regarding self-defense, right? Simply write a short note. So you have to cite that article and write three major point about these articles, right? You have to write these three major points about this article. Very important actually. Then what is the limitation? So limitation I already told you, right? There is a procedural limitation, right? There is a procedural limitation that you have to inform him, right? And see, limitation under the UN Charter that I already said, exercised only in the case of armed attack. Obviously it means the aggressor has to be identified, but preemptive is also there, remember that. And then it should not violate international humanitarian law, right? So international humanitarian law cannot be violated even if the strike is for the purpose of protecting yourself. Okay, so even if it is self-defense, international humanitarian law cannot be violated. Okay, and obviously find the case law, one case law, ICJ report will do, right, about each of one of them. Then international humanitarian law principle, right? So I have given a good paragraph that you could actually write, right? The understanding that I have already given you, what is the meaning. Then I have given you, 5 principles that obviously I am not going to, talk about that in detail, but that's still in a very brief manner I will try to explain it. First is the principle of distinction. It means that while attacking, you will distinguish civilian from non-civilian. Okay, if you are attacking a particular territory, then attack on civilians shall not be there, unless they are somehow found in aiding that particular attack. Okay, so the principle of distinction has to be followed. Principle of proportionality, you must be knowing it, right? That your response should be in proportion to the attack. Then we have military objective, right? Principle of military objective, right? It means कि your attack shall be in line with what you wanted to achieve, right? So if you want to capture a particular, particular port, right? So you cannot go and attack somewhere else which has nothing to do with the port. Understood, right? So see, the purpose of this particular principle is that you should not plan your attack as you go on. Okay, because it have a ability to damage a lot, right? So you should stick to your particular principle. That is a matter of trial. In the case of International War Tribunal constituted, this question is asked from the military leader that what was your purpose and what was your attack. Okay, so that is very interesting principle. Protection of civilian population, right? Distinction in that similar, and the precaution in the attack, right? So when you will attack someone, right, then you will take into account that you will not use chemical or nuclear weapon at all. Okay, however, ICJ have opined that when the survival of a state is at stake, right, then the nuclear weapon can also be used. Okay, as a last resort, there is no problem in that. Okay, that is a topic also in the nuclear. I will talk about that. I think topic number 15 or 16 is that. Okay, that talks about legality of the nuclear weapon, use of nuclear weapon. That I will talk about. Okay, right. So that is briefly, obviously I have not covered each and everything of that, right, but at least briefly, some part of it I have covered. Okay, now let us go to the previous year paper. Now if you look at the previous year paper, right, I have taken it from last year, de facto law website itself, right. Define intervention. See, very simple question. Mention the ground under which it can be justified, right? So in the case of armed attack, non-armed attack, there is only one ground: if someone is violating international human rights or humanitarian laws. Also throw the light of violation of this principle of international law, right? So it means that they are talking that how interventions should not be used, as a disguise to do an armed attack. Okay. Then the concept of necessity and proportionality are at the heart of the self-defense of international law. Basically, they are talking about the limit of international law. They are basically talking about the limit of international law. Explain in the light of UN Charter and the recent trend in expanding this preemptive or anticipatory self-defense. Right? So we'll talk about self-defense. Then you will write how Caroline incident actually established this concept of preemptive self-defense. Then you write philosophical point that why it is justified, because the survival of the state state is at stake. Okay. Then obviously then you will write that the international humanitarian UN Charter also recognizes this customary right, and then we will explain Article 51. Okay, very simple question. Legal restraint on the use of force in the fundamental postulate on which conception of the enforcement of peace is based upon modern international law. Enumerate and elucidate various international legal instruments with the help of which concept actually practiced, right? So it is basically talking about what are the I have given also what are the limitations on the use of force. Okay, you simply write those limitations and one or two legal instrument attached to it, right? Principle of necessity, not violate international humanitarian law, right? So you simply write okay, this is one of the thing that limits use of force, and then you write from where it germinates, right? It means you have to write the the base convention related to it, right? You have to write the base convention related. Again, a very simple question. Elucidate the fundamental principle of international humanitarian law as envisaged under international conventions, right? So these are the 5 principles. Simply write the major convention which actually provides for it, right? Cite articles. Okay, so that is the self-study you can do, I think. Then we have explained the concept of international easy question, right? So it is again very easy. How it can be achieved, right? It can be achieved by the state will. Okay, you can also hint that how there is no a general framework which will work towards its achievement, but still it can be achieved, hopefully. Critically examining the role of Hague and Geneva conventions, right? So we will write that how these two conventions, Geneva and Hague, both have germinated and has led to multiple conventions related to international humanitarian law. See, 2 conventions international law syllabus is very important. One is that Stockholm Conference in the case of environmental law principle, and Geneva and Hague convention in the case of international humanitarian law principle. Okay, so these 2 type of convention is very important. Understood that particular point? Clear? Good. So what question I should give you to write? let us give you question number. Let us today start with the easy question, right? So you please, if you want, you can write question number 4 and send it to me on PDF, right? You must be knowing, those who are old, de facto law.in @gmail.com. Okay. Again, I am not going to check each and every one questions. I will only check one of them just to show it. Okay. Anviti, I suppose, is here, right? Anviti, she writes good answers. She is already, I think, one of the student of the writing practice batch. She writes good answer, right? So I will request you, Anviti, you write and submit it to me. Okay. So that will be, and that will be good. Everyone will learn from it. Okay. Otherwise, all of you can also write, obviously. Chali. So that ends our today's class. Now, if anyone have question, now I am willing to take question. You can type, right? You can type. Old Consumer Act, obviously the Consumer Act which have been already been asked, you have to study. You have to study that only, not the new one. Okay. When the syllabus changes, then you will study the new one. Yes. Anyone else have any question? There is an option of raising hand in your. You must have seen there is an option of raising hand, right? So if you want to raise hand, right, you can raise and I will simply Yes, someone have raised hand. Where is my 1 minute. Who have raised hand? I don't know. There is some. Yes, I can see now. Yes, give me a minute. Yes, Avinit, go ahead. I have unmuted you. Ask your question if you have anyone.